Yes.
Members of the jury, Marcel Johnson knew exactly what he was doing. He knew exactly what was going to happen as he followed that red SUV being driven by Jalen McIntyre Burns. He knew that at some point he would have an opportunity. The person in the passenger seat, Kentrevious Garard, would have an opportunity. And he waited for that opportunity, the perfect opportunity, to open fire on that red SUV. And when Kentrevious Garard unloaded 22 rounds into that SUV, Marcel Johnson got exactly what he wanted. Vengeance. Revenge for himself. Revenge for his brother. Revenge for 320. And in that course request for revenge, he did not care who got in the way. Tragically, Prince Holland did get in the way. His life has been ripped away from him. 13 years of age. Jalen McIntyre also got in the way. He was the target. John Walker struck in the back by a bullet. Ezekiel Cooper and Rasheed Green had to live the rest of their lives with this traumatic event. Members of the jury, starting with the basics. In order to prove a criminal case, the state must prove two things. One, that a crime was committed. And two, that the defendant committed the crime. Typically, attorneys don't like to predict what is going to be said by the other side. But I can say with pretty high confidence that nobody's going to get up here with a straight face and tell you that a crime was not committed here. I'll take it a step further. I don't think anybody's going to get up here and tell you that the crimes that are charged were not committed. But I anticipate you delivering me whether or not the defendant committed the crime. And even though, again, these charges speak for themselves, I can't take that for granted. Because it is the state's burden to prove you beyond a reasonable doubt. What I'm going to do is I'm going to run through the main charges, the elements that the state must prove. What I'll do is I'm going to speak sort of in the abstract. We're going to take the defendant out of the equation for a moment. Speak in the abstract as far as somebody doing these actions and how somebody would commit these crimes. Let's start with the first element. Prince Holland is dead. That is not in dispute. While engaged in an attempt to commit murder in the first degree, somebody caused the death of Prince Holland. And we'll talk a minute about the attempted murder in the first degree, attempted premeditated murder in the first degree. But again, that charge is almost a given because we're talking about, again, 22 rounds being unloaded into a car. Somebody does not do that unless they are trying to kill somebody in that vehicle. They're not trying to scare them. They're not trying to hurt them. They're trying to kill somebody in that vehicle. It was Jalen McIntyre Burns in that vehicle, or juveniles. There's no reason, the evidence does not support any theory or thought that any of those juveniles were the target of this attempted first degree. In any event, we talked about felony murder in jury selection, and what we would call the underlying offense is that attempted murder in the first degree. And we'll talk about again in a moment. Third element the state must prove is that Prince Holland was killed by a person other than the person who was involved in this, and the person who killed Prince Holland were principals in the commission of the murder in the first degree. And I probably got to speak a little bit less in the abstract here. The person driving the vehicle in this instance was a principal for the person who actually killed Prince Holland. And in order to convict the defendant of first-degree felony murder, state does not have to prove that the defendant had a premeditated design to or intent to kill. And again, this applies to Prince Collins. So there does not have to be any proof that the state or that the persons that were responsible for this intended to kill Prince Collins specifically. Again, obviously as to the charge of attempted first-degree premeditated murder, the state does need to prove that intent. But as to count 2, to prove the crime of attempted first-degree premeditated murder, so the state must prove the following 3 elements beyond a reasonable doubt. But again, speaking in abstract, somebody intended to commit the crime of first-degree premeditated murder. That person committed an overt act toward the commission of first-degree premeditated murder that went beyond mere preparation. And so, just to take 2 steps back here, again, we have an individual who is driving a vehicle from which a passenger is firing off 22 rounds at and into an SUV. As far as count 1 is concerned, the evidence that you have does not contradict that or show that there was not an intent to commit premeditated murder in this instance. And of course, these individuals drove a vehicle, they pulled up on somebody and fired rounds. Obviously, there was an intent there. There was an overt act. And that the person failed to complete the first-degree premeditated murder. Now again, make sure we parse this out. This applies to Jalen McIntyre Burroughs. And they did fail. They failed to kill Jalen. Instance. Going further, if the state had proven the actual murder, if Jalen had died, the state would have had to have proven beyond a reasonable doubt that he was dead. That the death was caused by the criminal act of this abstract person. It's the argument here, the person was driving a vehicle, the person shot into that vehicle, the person driving the vehicle assisted and aided. And that there was a premeditated killing of Jalen McIntyre Burroughs. Beating a dead horse here, but again, 22 rounds. There's no other reasonable explanation as to why somebody would shoot 22 rounds. Now, this counts 3, 4, and 5. Attempted second-degree murder. This applies to Ezekiel Cooper, Rasheed Green, and Talent Walker. And to prove the crime of attempted second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. A person intentionally committed an overt act that could have resulted in the death of Talent Walker, but did not result in Talent Walker's death. And then you can exchange Ezekiel Cooper and Rasheed Green in there. And that's why that count 1 is worded the way it is. The act was eminently dangerous to another and demonstrated a depraved mind without regard for human life. We'll get to that definition in a moment. All legal jargon. And lastly, the act went beyond mere preparation. This act absolutely, very clearly went beyond mere. So an act that is eminently dangerous to another and demonstrates a depraved mind is that if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another. So even though these individuals intended to kill Jalen and did kill Prince Holland, as it applies to the 3 surviving juveniles, the fact that Prince Holland died shows that this is an act that would reasonably be believed to lead to death or great bodily harm. Serious bodily injury. The act is done from ill will, hatred, spite, or evil intent. The actions speak for themselves. It was an infringement act. This was not an act of, oops, my gun's going off 22 times. This is an act that was done intentionally with ill will, evil intent. It is of such nature that the act itself indicates an indifference to human life. And human life was lost here. The person shooting in that video did not care that person was did not care that these 3 juveniles were in. Convicted defendant of attempted second-degree murder, it's not necessary for the state to prove the defendant had an intent to cause death. So again, there does not have to be any intent whatsoever that the person firing this vehicle or firing these shots, that the person driving the vehicle, there's no proof, there's no need for proof that they intended to kill the 3 people who did not die and were not the target of this premeditated murder. All right, so the judge went through these lengthy lesser included offenses, and I'm going to spare you. I'm not going to go through all of these because, again, this is a situation about whether these defendants committed the act, not whether these acts were committed, not whether the state has proven that these acts were committed, that these crimes were committed. So what lesser included are, again, are just basically charges or crimes that the main charge has several elements. These lesser included essentially are missing maybe one or more of those elements. They're sort of subsumed into the main charge, if you will. So for first degree felony murder, the lesser included is manslaughter. For attempted first degree premeditated murder, the lesser included are attempted second degree murder, attempted manslaughter by act, aggravated battery, and battery. And for attempted second degree murder, the lesser included is attempted manslaughter by act. And one thing that I'll point out, as you saw on the verdict form, is that there will be also a choice that you have to make whenever you are making your findings. You'll have to make a finding as to whether or not the defendant was in actual possession of a firearm, whether that was discharged, and whether that discharge caused death or great bodily harm. That's not on all of the charges, but on some of those charges. That will be a finding that you have to make if you find the defendant guilty on some of those lesser included. Okay, so, like I said, that brings us to where we're really here, why we're really here. What did the defendant commit the crime? What I'm going to show is just a brief outline of what I'm going to show here. It shows that this defendant absolutely committed a crime, intended this crime to be committed. So first off, Mr. Johnson had motive and intent for this crime to occur. And that will come, I'll explain that, why that's important in a moment. The cell data and the surveillance demonstrate that this was an incident where the defendant intended for this act to occur. And of course, you have the defendant's confession, his own words that demonstrate that this was something he intended to occur. So before I get into the evidence, one last thing I want to touch upon regarding the instructions. Talked about this in jury selection. The example that I used was the driver of a bank robbery. Even though that person doesn't even go to the bank, they can be found guilty because they aided in the commission of the bank robbery. Well, just as that is the case with that example, this defendant was the driver of a vehicle, an individual in that vehicle who committed a crime. And he aided that individual committing the crime by driving him to the location where the crime occurred. You'll be instructed that if the defendant helped another person or persons commit or attempt to commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the state proved beyond a reasonable doubt 2 things. 1, that the defendant intended the crime to occur. And 2, that the defendant did some act or said something that was intended to and that did incite, cause, encourage, assist, or advise the other person or persons to actually commit or attempt to commit the crime. If we go back to the abstract, we can say that the person that was involved in this was driving the vehicle that took the person to fire the gun into the SUV. That is absolutely an act that is intended to assist the individual who's actually firing the gun. For attempted first-degree premeditated murder, the state must prove the defendant intended that the killing of Jalen McIntyre Burrs occurred. And again, we're going to get to that in a moment. Now, as to the first-degree felony murder and attempted second-degree murder, it is not necessary to prove that the state proved that the defendant intended the death of Prince Holland, Talent Walker, Ezekiel Cooper, and Rasheed Green. So, as it applies to those charges, the state does not have to prove that he intended on those individuals being killed. Keep that in mind, and you'll have instructions back to it. All right, right, so what evidence have you seen that demonstrate that this defendant had a motive and intent that this crime occurred? Let's start with the background here. The backdrop that kind of lays everything, sets the stage for what happened here. We've heard a lot about 3 and 320. Two groups that don't like each other and have had multiple instances in the years preceding this incident of violence. Starting with the 2019 barbershop incident. It was an incident where Isaiah Pringle, who was Emmanuel Pringle's brother, was shot, permanently blinded. This defendant was also shot during this incident. And for Kobe Johnson's testimony, Jalen McIntyre Burroughs is the person that they suspect of committing this crime. But as you heard through testimony, nobody cooperated in this case. Moving forward to 2022, an individual known as Wicks, who was a member of 3, he's killed. June 2022, Joshua Holmes, who is a member of 320, is killed. And again, per Kobe, 3 was suspected as being responsible for the killing of Joshua Holmes. One thing that I'll insert in here also is just keep in mind is that in January 2022, that is when Kobe bought the Zastava rifle that was used in this incident. After Joshua Holmes, member of 320, is killed, Corey Poole then takes to a rap and disrespects Holmes in a rap, and further inciting this cycle of violence, further inciting 320. September 20, 2022, that's when Kobe was jumped at the car wash fundraiser. He stated that Jalen was there at a distance, and that when he was jumped, Marquise Holloway, who is Jalen's brother, was there and actually was involved in the jumping of Kobe. Kobe suspected that Jalen is the one that alerted these other individuals who came and jumped him that he was there. And as they're jumping him, they're chanting, F Josh, R.I.P. Wicks, according to Kobe. After this happens, and also, by the way, Kobe stated that while he's getting jumped, he's also yelling threats to him that basically telling him he's going to get back at him. So after this happens, Kobe FaceTimes the defendant. And you've seen a photo of that, and that's in evidence. FaceTimes him, you can clearly see that Kobe has these injuries that result from this jumping. So now this defendant is aware of what has happened to his little brother. And what you see in 2022 is this violence happening more frequently for something. Because again, the barbershop incident was 2019. And there was an incident at a football game where Kobe got into a fight with Jalen. And they got better on him. But in 2022, for some reason, it seems to ramp up. Kobe also talked about being at a gun range, firing off a gun, and that apparently he claims that Jalen laughed in a reaction on a post or something along those lines at his post about shooting at a gun range. He also talked about how Marquise Holloway, again, brother of Jalen, was threatening to kill Kobe. And Kobe took that threat seriously enough for him to leave and skip town for a while and go to Tallahassee. He also began driving rental cars instead of the car that he was known to drive. The defendant was also producing rap, and according to Kobe, because of the raps that the defendant was producing, again, this further incited threats from Marquise Holloway. So let's move on. We've got, like I said, we got the background here. We've seen what is leading up to this incident, the back and forth going on here, retaliation going on here. So let's move to this specific incident, start getting into what the state has proven in terms of connecting this defendant and linking him to the vehicle that was driven in this incident. So let's talk about cell data. Calls and location. Well, as you learn, calls to Mr. Garard start at around 12 p.m. At 3:58 p.m., Bennett calls Garard after dropping off his grandmother a few minutes afterward, and he is in a blue Kia Rio. And I'll back up a little bit. You also saw the surveillance footage showing the defendant at around 2 p.m. exiting a building and getting into that blue Kia Rio. Location data shows the defendant traveling towards 7th Street, which is where Mr. Garard lived at the time. At 4:19, the defendant called Mr. Garard while pinging at the closest tower to Mr. Gerard's house. And after that call, at 4:19, calls to Mr. Garard stopped. I would submit to you that because they were then together at that time. Multiple calls before. And after that 4:19 call, there were only two calls shortly thereafter, the last one being at 4:24 p.m. There's not another call from the defendant until 6:37 p.m. That's to anybody, to be clear, that's to anybody, not just to Mr. Garard. At 5:45, this defendant's cell phone stops communicating completely with the network. And I know that you've heard testimony or claims that could have been due to the phone being dying, being low battery and dying. And perhaps that happened. I'm not going to sit there and pretend that I know what happened in that situation. But what we do know happened is that after that 5:45 point, his airplane mode was turned on. We do know that. For some reason, cell data doesn't document whenever airplane mode is turned on, but it definitely does document it when it's turned back off. 6:15, the only other activity you really see on the defendant's phone is brief access to maps. Murder happens at 6:19 p.m. And then the phone is then turned on again 15 minutes after the murder. And more importantly, airplane mode is then turned off. Members of the jury, that is called what we call consciousness of guilt. Somebody that is doing something to try and hide evidence or because they are guilty of doing something wrong. And that cell activity, indicative of his intent. That is, he's doing these things because he knows that he is about to participate in this crime. It's not just coincidences. He's not just a very unlucky guy. He's doing these things because he knows that he and Mr. Garard are about to go looking for Jalen McIntyre Burroughs. He does not want to be tracked. He does not want to be shown to be at the crime scene. Let's talk about surveillance. Again, I mentioned we see the defendant get into the blue Kia Rio around 2 p.m. Fast forward to the footage off of Sutel Drive. You see, again, the red SUV coming down Sutel, heading towards Moncrief. And one thing to point out is you learned through testimony again that Jalen's brother Marquise sometimes drove that SUV. Jalen was driving it on this occasion, and he had, again, the 4 individuals with him, leaving this football tryout or practice. Within 10 seconds, and from the distance, you see the blue car come to the picture. You see it come off a side road and turn onto Sutel Drive. Start driving at a pretty fast rate, frankly, following behind the red SUV. Now, this is not part of the plan for the defendant. An ambulance shows up and causes Jalen to pull over, to try and stop, causes this other vehicle to not know what it's doing and awkwardly kind of drive in the middle of the road. And then there's an accident a little bit further down that causes Jalen to have to stop and wait. liquor store video is you see the SUV sitting there. Excuse me, actually, you see the defendant's blue Kia Rio sitting there. And because it had passed the SUV. And it's just sitting there waiting. It's almost like you can feel like they don't know what to do. And then you see this red SUV pull up next to the vehicle. And they're literally right next to each other. And again, it's almost palpable, the awkwardness. You see the blue Kia Rio kind of pull off to the side, going to the parking lot. You don't see where it goes, but Detective Mittling, one of the detectives testified that basically where that car went, there was a side road that feeds right back onto Sutel Drive. What you see after that point is the Walgreens footage. You see, again, what you can kind of see from, coming down Moncrief, coming at you, going behind you, and crossing over in front of you, you see Sutel Drive. And you see the red SUV sort of pull up and slow down because the oncoming traffic is coming down Moncrief Road. And then at 6:18, there's the footage of the murder itself, taken from a gas station. And, I encourage you to look as much as you need to. But you can make out who is who from a distance whenever you watch that footage. And what you see is that the white Charger that's at issue, we'll talk about that in a second. That white Charger that's been made an issue pulls up and is in front of the red SUV. As a matter of fact, it's in front of that red SUV at all times. And then you see the red SUV coming up, you can make it out by the fog lights on it. It pulls up, and then you also see two headlights to the left of it coming up at a faster rate, and you see one of the muzzle flashes. But you clearly know that something's happening because from the footage, people start kind of ducking, that you can tell that they're hearing the gunshots going off. Then, of course, Mr. Olds, who's just trying to protect his family, books it, takes off. So this is the footage we're talking about. And again, this pauses automatically, so I'm not going to be able to keep it paused. But again, you see the white Charger coming up to the light, stopping in the middle lane where you can go straight on Moncrief. See this car coming, turning onto the right, Kings Road, and that car in the back there with the fog lights on, that is the red SUV. You see that pulling up. And what you see from there is you can see the car on the left pulling up beside it. There's the muzzle flash. See the white Charger take off. And you can't see it actually happen, but behind that post is where that blue Kia Rio cuts off somebody going straight and comes down New Kings Road. So, that white Charger been made such an issue. But it does not make any sense for that white Charger to be involved. And the evidence excludes, it literally excludes this white Charger from being involved in this incident. Practically, at least. Nobody knows who Jacob Olds is. Marcel Johnson was asked, no idea. Yeah, I actually had to ask Mr. Brown who you're talking about. Daniel Pringle, no idea. Jacob Olds is. He's not somebody that's been in any of these rap videos. He's not somebody who's related by blood or close friendship to somebody who was shot or had violence done to them by three. Why? And if he's involved in this, why would he be there? And I asked that question because, as I stated earlier, he is in front of the SUV at all times. We know that the SUV was struck with gunfire from behind. There are 3 or 4 gunshots to the back of the SUV. It is impossible. Unless somebody has a magic bullet in that white Charger, it is impossible for that person in the white Charger to have done that shooting. And we know that the shooting was all done from one gun. That gun is a stop. That's because Megan Sarnak with FDLE came in and told us. She compared them. They all matched. They all came from the same gun. So it's not like some came from one, some came from another. These all came from one gun. And it is literally impossible for the person in the SUV, in the white Charger, to have conducted a shooting. So what in the world is he doing there if he's somehow involved in this? Is he on a walkie-talkie talking about, hey, they're coming up? Well, we know that's not true. And the reason being, we'll get to that in a second. And what actually we talking about. So the reason being is that this footage, again, that is from the Walgreens at the corner of Sutel and Moncrief. Again, I encourage you to watch this as much as you need to watch it. Because what you will see is the victim's SUV pulls up. There's no other cars right behind it or anything at that moment. It stops because the oncoming traffic is coming down Moncrief Road. And all of the cars coming down Moncrief Road, all those cars coming down Moncrief Road in front of the red SUV are coming from Moncrief. They are not coming from Sutel. So unless one of these vehicles that has been made at issue has some sort of magic device where they can predict where the SUV is going to come from, there's no way that they are involved. They're just coming from Moncrief. There's no way they can know where the victim vehicle was. There's no way for them to know that. And again, you watch this video, and every single vehicle you see in the rec center video, every single one of those is a vehicle that's crossing over Moncrief, except for this car that's turning out of Walgreens. That's the only other vehicle that ends up behind the red SUV. So again, that excludes any of those other vehicles being involved. The only vehicle that you see continuing to follow the red SUV is a vehicle being driven by the defendant. Again, you got the video from the rec center. You see the white Charger just go by. Literally 7 seconds after the white Charger goes by, that's when you see the SUV. If he is trying to monitor the SUV in some fashion, he's doing a really, really bad job of it. But right behind it, you see that blue Kia Rio, right on its tail, ready to make its move. And so at the end of the day, the white Charger, I call that a red herring. Something to distract you from the evidence that you really need to pay attention to in this case. And Juwan Thomas, he's another one. He's another red herring. Juwan Thomas was not involved in this incident. You have a statement on social media 37 minutes after the incident. Why would somebody immediately jump on social media and incriminate themselves? Something where they know it's going out, everybody can see it, and incriminate themselves and say, I think I did it. Yes, I did. But I'm not going to stand up here and pretend that there aren't some sick individuals out there that would claim responsibility for a 13-year-old's death, because there are. There are other individuals out there, and Mr. Thomas demonstrated that he is one of those individuals. Because at a later point in time, he did say something whenever somebody asked him about the shooter. He said, well, you might be talking to him. He was not a shooter. The reason why we know he's not a shooter is because they still treated it as a lead in the case. They didn't just ignore it, as the defense might want you to believe. They did not just ignore Juwan Thomas. They looked into Juwan Thomas. Detective Mittling testified that he still investigated it. He found no known numbers that could be confirmed as belonging to Juwan Thomas. One number that he could find, or that they somewhat connected to him, showed that that phone was in a different location from the crime scene at the time of the crime. Detective Mittling looked up his family, his friends, any close associates that might have a blue Kia Rio or a blue sedan and found nobody that had a blue sedan to which the defendant, or excuse me, that Mr. Thomas would have had access. He made no confirmed connections from Juwan Thomas to this crime. And to also kind of put it in perspective, at the same time, while he's investigating Juwan Thomas, he is also following leads on this defendant. And part of those leads involves the defendant's cell phone records that show his phone call, Mr. Garard, shortly before the murder happened. So that is a lead that they followed based on that. So they're following up on these other leads. And then, of course, the defendant confessed. He admitted to being the driver. What kind of use of police resources would it be if the defendant admits to being the driver of the vehicle, tries to point the finger, and they say, well, you know what? Even though he told us he did it, he had some over, let's keep investigating this Juwan Thomas character. Let's keep pouring resources into that guy. And we have no reason to believe he's involved. Again, distraction, red herring. So let's moving further with the cellular data. Next activity that we see on the defendant's phone is being powered back on and airplane mode being turned off. And as I stated earlier, it doesn't show when it's turned on, it does show when it's turned off. So we know that it was turned off at some point between 5:45 when it stopped communicating with the network, or at 5:45 exactly, perhaps. But at some point after 5:45 at least, it stopped communicating with the network and airplane mode was turned on. I know that because it was then turned off at 6:36. You have the phone call at 7:50 where Mr. Garard calls Kobe. Kobe and Emmanuel Pringle go to Gerard's house. And the location data for the cell phones is all consistent. It shows these three individuals congregating at the defendant, or at Mr. Gerard's house. I know there's been some, questioning being made of, well, we can't say exactly where we can't pinpoint the exact very location that they are. And that's true. I'm not going to sit there and claim that's not true, but you have phone calls to these individuals, and phone calls previously between these individuals. It does not make any reasonable sense to conclude that they were not congregating together, that they were not together at Mr. Gerard's house. And on top of all that, Mr. Pringle's GPS shows him there too. So we know that they all gathered and met at that location. And that's consistent with all of the evidence that you've heard. They all met up in Mr. Gerard's house. Also consistent is that they then, from there, went to a friend, Pete's, a guy that cleans cars. Why on earth would they do that? Well, they just need to clean the car, apparently. Well, no. They're going to get the car cleaned quickly because they know what they just did. The defendant had Kobe take the car back to his grandmother's, but because Kobe was driving his own vehicle, he had Emmanuel Pringle drive the blue Kia Rio. At 8:18, they all again congregate at the park, which is consistent with the records, it's consistent with the testimony. So this happened. During this incident, Kentrevious Garard brags Emmanuel Pringle, Kobe Johnson, and he sprayed that bitch up. Think about it for a second. Why is he bragging those two people? Because Emmanuel Pringle's brother is permanently blinded, shot in 2019. Because Marcel Johnson, the defendant, was shot during that incident. These are the people that he wants them to know he got vengeance. Now, as far as Kobe Johnson's involvement, first denied everything. And it's not uncommon, not unusual to hear that somebody that may be affiliated with activity might deny being completely involved and deny any knowledge whatsoever. Claims he didn't know anything about the barbershop, or didn't say anything about the barbershop at least. Didn't say anything about the style of a rifle. Didn't say anything about being jumped. Complete denial across the board. He did not want to be involved. Did not want to be a snitch. Now, when he took the stand, at no point in time did you hear him say, "I lied when I said that," or that he heard Garard's statement about spraying the bitch up. At no point in time did he say that. He said he felt pressured to say what they needed me to say. And perhaps he did. He was subpoenaed, forced to show up. And we needed to hear the truth. So yeah, he was forced to show up and tell us the truth. His attorney was there. This talk about him being threatened or feeling threatened or pressured, he had an attorney there with him. As Mr. Grau pointed out on cross-examination, there's an attorney being there, a cop or a police officer is not going to blatantly pressure a witness in front of an attorney, a barred attorney. That's not going to happen. There's been some talk about a probation officer also maybe giving some pressure. Probation officer does not care whether or not Mr. Johnson is involved. Their job is to monitor people. Their job is to make sure people show up for things. They're not there. They don't care. They don't have a dog in the fight, so to speak. He said something about somebody telling him what Emmanuel Pringle said. We know that is absolutely false. Because Emmanuel Pringle was not interviewed until a month after Kobe Johnson gave his statement. There's no way that anybody could put any sort of statement in front of him and said, "This is what Emmanuel said, what do you say?" It didn't happen. That didn't happen in that order. This is coming from Kobe Johnson. This is from his own memory as far as what happened. But this also demonstrates his attempt to distance himself from what he has done. He knows he got the defendant in trouble because he implicated Mr. Garard. But he is trying to backtrack now and say, well, I felt pressure, this, that, and the other. It's not consistent with evidence. It's not consistent with common sense. During his testimony, that said nothing about playing Grand Theft Auto. I want to talk about NBA 2K and a football game. And that becomes important when it comes to Mr. Pringle's statement. And the question is, why would he implicate it? Why would he make up this statement and attributable to Mr. Garard? Why would he do that? There's nothing for him to gain. The idea is that for some reason he felt compelled to implicate it. But if he felt compelled to lie, why not pick just a random Joe? Why not pick a Drop or a Slim or some other person that doesn't have the kind of connections that Mr. Garard has to the defendant? It makes zero sense for him to completely pull this statement out of thin air. More importantly, why add the part about seeing Prince's head hit the window? Why? That adds nothing. And so he has nothing to gain by fabricating that. He's already testified about the statement. If all he has to do is come in and say, "Yep, that's what I said. See you later." That's all he had to do. But no, in that proceeding, he added that part what he heard, and there's no reason for him to have done that. Other than one reasonable explanation, and that is because he was placed under oath. Now, Emmanuel Pringle, same situation. He did not want to be here. You can tell it by his testimony, you can tell it by his plain words. He did not want to be here to testify. But again, at no point in time during his testimony did he say, "I lied about what I heard." Also, he never said anything about hearing anything, he never said anything about Grand Theft Auto or playing Grand Theft Auto when he first spoke to police. He talked about the statement made by Mr. Garard multiple times, but not at any point in time did he clarify and say, but we were playing Grand Theft Auto, and that's what we're talking about. He didn't do that until he was opposed and when he came in here and spoke to you. And let's just think about that concept briefly. And that is, does it make any sense whatsoever for grown men to go to a park and brag about a video game, what they did on a video game? No. I don't play video games myself, but I know common sense. That makes zero sense for people to gather and just brag about what they did on a video game. And again, why implicate Mr. Garard? He considered him his brother. And then he knew that he got Mr. Garard in trouble. That's why he came in and tried to say that they were playing Grand Theft Auto, and that's what he was talking about. All right, I know I got a little sidetracked there, but let's go back to, and that's just to kind of show you the connection between the defendant and Mr. Garard and what they did together. Because again, you have the evidence showing that he went to Mr. Garard's house, that they were together, and at some point after that point, the murder happened, 6/19. So what other evidence do we have that this defendant had the intent, the motive for this crime to occur? Well, we also know that he had the opportunity, because you saw the video where he has the Zastava style rifle. And as Kobe testified back, that he bought it in January 2022, but when he went to jail for something, somebody stole it. Somebody had his Zastava rifle, and he doesn't know who had it. We know who had it. It's his defendant. We know the murder was committed with Zastava because of Ms. Sarnak's testimony. Firing 10 created a unique ring around the casing. Never fired from Zastava. Holding this rifle in the video that we saw, and that you'll have if you want to watch. Got to get ahead of myself, apparently. So we talked about how he bought the Zastava. And he said now, the last time he saw it was in August of 2022. He did admit, however, that he saw the defendant with the Zastava once or twice. So, again, this rifle belonged to, technically belonged to Mr. Johnson, Kobe Johnson. But the defendant clearly had taken possession of the rifle and had it. So this rifle did not belong to Mr. Garard. The defendant brought this rifle to the table. And that, again, is part of what proves that he intended on this happening. He brought the murder weapon to the murder. That's not proof of what he intended on happening. I don't know what is. And how do we know he had that murder weapon up to days before the murder occurred? Because you have a photograph that was pulled from his phone. A photo that was created on November 29th, 2022, again, a mere days before the murder occurred. Then, of course, we have his confession. And as you saw, picks up where he's speaking to detectives. He asks to see them, asks to talk to them. And when they start questioning him about, all right, why'd you want to talk to us? He just begins telling a similar version of events as before. Slim and Drop somehow got his vehicle after telling him to go to the store or something. And that Slim and Drop disappeared with the vehicle for some time until they came back at some point, like an hour or so later. And he gives this completely detailed account of what happened on December 3rd, 2022. Down to the turns that he made at points, who he spoke to, what he did. Remember anything detail about the next day, December 4th. For some reason, December 3rd, he was able to give details of that. About that following Sunday, he had nothing to give. So what we had here was statements being made over and over again by the defendant, being refuted, being shown evidence by Detective Mittling, contradicting what the defendant was saying in the interview. And he keeps changing and adding details to try and keep up with the evidence that keeps being shown. But it's becoming clear to him that ain't working. He's not able to talk himself out of this. So he finally confesses. Finally comes clean what happened. And when you'll notice that whenever he starts talking about what happened, it flows. It flows freely. He's not, the detective is not leading him. The detective is not saying, did this happen, right? Did that happen, right? The defendant is just flowing with the information. The detective is just saying, well, what next? What then? It wasn't like what before, whenever he would say something and the detective would ask him a question and he'd say, huh? What? And we would repeat the question, things like that. He discusses the events leading up to following the SUV, talking about meeting with Garard at Garard's house. He said that Garard had an agenda. He wanted to kill Jalen. Said that they discussed, or at least Mr. Garard discussed the plan, but they were both discussing the plan and how they're going to affect this. Discussed following the SUV, and then they actually do begin. They go back out to, or they go out to Legends Field where they had seen the vehicle before. They started following it, and according to the defendant's interview, he's feeling this pressure that Mr. Garard is pressuring him into it. He's driving along, and that Mr. Garard is just telling him things, trying to encourage him, or again, pushing him into doing this, as if he's not the one that brought the rifle to the, as if he's not the one that's driving his grandmother's vehicle. And he claims that he got sort of cold feet, tried to act as if he lost the vehicle. But that didn't work either, supposedly. And all this time, first off, the gun was already in the vehicle, as he admitted. And at some point, Mr. Garard puts the gun between his legs, ready to go. And he said that Mr. Garard then just opens fire. The evidence does not support that. Like I said before, all statements flowed freely. The evidence does not support that version of events. It shows the defendant driving that vehicle methodically, following, stalking, and at one point having to figure out what the heck to do once he caught up and passed the SUV. That's what the evidence shows. That's not somebody who is feeling pressured doing something. At no point in time during the interview did he say that Mr. Garard threatened him or tried to and say, if you don't do this, then I'm going to, shoot you as well. Nothing along those lines. Never at any point in time. Never pointed the gun at him. No point. Let's talk about this confession. And let's be clear here. I'm moving towards voluntariness of the confession because the questions posed to Detective Midland imply that this was something that was forced out of the defendant. So now it's gone from, I didn't know this was going to happen, to now, I falsely confessed. I was forced to confess this. That's what we're dealing with now. And so that's why I'm going to go into the voluntariness of this. So, his confession, voluntary and uncoerced. This was the second interview. The defendant knew what to expect. This was not like he was ambushed, dragged in from somewhere, and this is the first interview without anything, like having no idea how it goes. He knew exactly how it was going to go. And despite that, he initiated the interview. He reached out and said, I got something I want to say. He acknowledged his rights again. That commitment made sure that he saw the form again, he read it again, signed it again. He knew his rights at that point in time. He's a 22-year-old man. This isn't some 14-year-old juvenile being pressured by two mean, big, bad adults. This is a 22-year-old man in there being interviewed. He said he's been sleeping fine. Even when the detective gave him a chance and said, you haven't been sleeping well, he said, yeah, I've been sleeping fine. I might do some medication, but bottom line is he's not sleep deprived, he's not in some vulnerable state. He's completely fine. Interviews at 1:30 p.m. And I point that out because, again, this is not some situation where they drag them out at 3 o'clock in the morning with dead sleep. Say, all right, tell us what happened. What do you want to talk about? This is in the middle of the afternoon. There's no kind of, tactic here to try and get him to say something he didn't want to say. The confession happened about an hour and 15 minutes of that interview, that second interview. This is not a situation where this was dragged out for hours on end, where the defendant is just finally just caving to this never-ending questioning. And yeah, at one point in time, Detective Dravick does say, Dravick says, we're not going to stop. And that, I'll submit to you, what that means is we're going to keep investigating this. You're going to keep getting evidence. And he even kind of corroborates that at some point by saying, either jump on the train or not. So again, paraphrase, but either get on board or not, because we're not going to come on and talk to you once we have more evidence, once we've got something strong. Or even strong. No threats or physical acts. Finding some light touching, that is something that detectives do during interviews. But he's not being roughed up, not being held against his will. They're not just completely, at times they raise their voice, yeah. This is not a constant, never-ending berating. And again, there are no threats whatsoever that are made to him. If you don't confess, we're going to do X, Y, Z, nothing like that. And as I stated earlier, there's no leading. That commitment was letting him flow from the defendant without giving him the information that he wanted to hear. It was just, what next? What next? One thing that doesn't make sense is he admits to, early on when he talks about, he admits to that it's his grandmother's vehicle that was used. So yeah, it was my grandmother's vehicle, and admits that it was his brother's Estado that was used in crime. Was that coerced? None of it was. One thing that I'll point out about the interview is that even though he comes clean and admits to driving the vehicle being driven by, driving the vehicle that Mr. Garard shot from, he still stopped short of admitting, again, that he knew this was going to happen. And the reason he does that, and it's because of his inability to admit what he can't deny and deny what he can't. That's the saying we have in our world. If what you can't deny what you can't say. So finally he realized that he had to admit what he couldn't deny. He was the driver of that vehicle. The evidence, again, Detective Midland was speaking the evidence. He knew that eventually he had to admit that he was the driver of that vehicle. But he maintained and denied because he could not admit that he knew that this shooting was going to happen that ended up killing 13-year-old Prince. That's why he did not go that final step of admitting that he was involved in this purposefully, intently. So let's talk about this video that happens, that's seen on December 5th with the defendant.
Mr. Powell, I'm going to get you to pause just before you start talking about the video while they open that door. Officer Mills, tell Miss James to knock before she comes back out. And then I'll call for another brief pause. We're all done. All right, that closed all the way? All right, you may proceed.
Thank you, Your Honor. So this video that the defendant posts on Instagram Live on December 5th, this video demonstrates this is not somebody who did not want this crime to occur. This video shows that this was not a coerced confession of somebody that had no involvement in this. This is the video of somebody who's bragging and gloating.
Exit out your PowerPoint.
We don't need to hear what's said. That's one of the highlights. Trying to be distracted from the movie going on. So during this interview, or not this interview, but this Instagram live.
Bro, you can't. You supposed to be at the hospital or something, dude. Folks are barely making it in that. Damn. Shit, it's really around the way. It's busting around the way. They say it's busting on 8th Street. Like, you don't got no cube or nothing, so we really can't be talking. You not part of the club, Jet. Get you a cube or go do something to somebody. Till then, you come back talk to the big homies when you do one of those. Till then, he talking about, I think it's an award ceremony. Yeah, at the grave site. Oh yeah, if you ain't just stay in the crib, bro. That's my best suggestion. Ain't buttoned up, stay over. You don't got to do with nothing. Phone them grave. If you ain't yeah with the yeah, stay your ass under them roofs. I'm telling you. What you telling? Damn, 3. Thought you would have your way out here. Don't you got a jet? You got a baby on the way or something, jet. Go take care of your jet. You know, got 3. You know how to come in. Missing my homie for him, we get back. Banging free smoke out of K, don't do that. Don't do that. Especially if you ain't got no Cuban on the back of that bitch. R.I.P. my brothers, man. Niggas know how to 320, she's 13, shit.
That's not a video from somebody who was just taken by surprise or upset about Mr. Garard opening fire without his expectation or knowledge. And as somebody who was proud of what he has done. Somebody who's proud of acting on behalf of his brother, on behalf of 320. Members of the jury, as stated at the beginning, the defendant knew exactly what he was doing, knew what was going to happen. In his interview, maybe a talented rapper, he could not find the words to talk himself out of this one. That is why he confessed. That is why he admitted he did. But the confession is only telling us what we know, just like the detectives. It was just telling them what they already knew. Now, that confession is just confirming what you already